Dear students, today we are going to deal with the topic contract and its essential elements. Before going that, what is Indian Contract Act? Indian Contract Act is the act which came on force on first day of September 1872. The word contract is derived from Latin language from the word contractum. Contractum means drawn together. Then what is contract? Contract is an agreement which involves parties, and the parties have certain rights and obligations under the contract and which is enforceable by law. That means contract is an agreement between the parties and parties have certain rights and obligations under the contract and they are enforceable by law. Then what's the definition of contract? As per Section 2, Subsection H of Indian Contract Act 1872 defined contract is an agreement which is enforceable by law. That means an agreement, there are two things are there, an agreement and then enforceable by law. Enforceable by law means enforceable through the court of law. Then what are the essential elements of a valid contract? Before going to that, as per Section 10 of Indian Contract Act says that a contract is treated as a valid one, then the parties must have the legal capacity to enter into a contract and the parties provide their free consent to enter into a contract and the contract must have a lawful object, lawful consideration and the agreement should not be declared by the court as a void one. Remember in mind, these are very important for making a contract, and then we are going to discuss regarding the essential elements. There are 10 essential elements of the contract. Then first one, agreement. There must be an agreement between the parties of a contract. The agreement involves valid offer by a one party and the valid acceptance by the another party. There should be an agreement involved between the parties and the agreement contains valid offer by one party and valid acceptance by another party. For example, Mr. A agreed to sell his car to Mr. B for rupees 5 lakhs. Here, there is a valid offer from the part of Mr. A. That is, he is ready to sell his car for rupees 3 lakhs to Mr. B. So, next essential element, identity of mind or consents at idem. That means the parties of a contract must have the identity of mind regarding the subject matter of the contract. That means both the parties understand the subject matter in the same time, in the same sense. Otherwise, it is treated as a void contract. For example, Mr. A has two houses. One is at Cherupuzha and another is at Padichal. While making an offer with Mr. B, Mr. A has in his mind a house at Cherupuzha for the sale. While accepting the offer, in the Mr. B's mind, a house at Padichal for the sale. Here, there is no identity of mind. So, it is not treated as a valid contract. Then third essential element, capacity of parties. The parties to enter into a contract must have the legal capacity to enter into a contract. Legal capacity means he or she should be a sound mind, then major and not disqualified by any law. Sound mind means a person who is capable of making rational judgment. Then major means a person who is attaining its 18 years or he attained the majority. Then next one, free consent. While making a contract with the parties must provide their consent to enter into a contract and the consent must be free. When the consent is said to be free, it is not influenced by coercion, undue influence, mistake, misrepresentation and fraud. If the consent of the party is obtained by way of these 5 things, it is treated as, that contract is treated as a void one. Coercion means threatening a person or property to obtain the consent to enter into a contract. And undue influence means there is a special relationship between parties and the one of the party use the dominant power to enter into a contract by other party that power is used for entering the person to entering into a contract. For example, teacher student, doctor patient, like that. Next one, lawful consideration. The valid contract must be supported by a lawful consideration by both parties. Consideration means something in return. That means when one party offers to something to another, he must be benefited by something. That benefit, the concept of benefit or that benefit is known as consideration. So a valid contract must fulfill the essential element, that the valid consideration. Next one, lawful object. The parties to a contract must be entered for the lawful object, otherwise it is treated as a void contract. Lawful object means the object of the contract should not be illegal, immoral or against to public policy. If the object of the contract is illegal or immoral or against to public policy, is treated as a void one. Next one, terms of agreement must be certain. While making an agreement, both the parties should clearly specify the terms and conditions of an agreement or a contract in the agreement itself. Otherwise, it is treated as a void one. For example, Mr. X make a contract with Mr. Y to sell 10 liters of oil to Mr. Y for ₹1,000. It is not treated as a terms or not treated as a terms or contract are clearly specified, because which type of oil he is going to sell is not mentioned. So, while making a contract, the terms and conditions of a contract clearly specified in the agreement itself. Next one, possibility of performance. While making a contract, there should be a possibility of performance from the part of both parties. Otherwise, it is not treated as a valid contract. That means both the parties are capable to perform something. For example, Mr. A made a contract with Mr. B. He is ready to provide ₹10,000 to Mr. B if Mr. B bring a gold from moon. Here, it is not possible by Mr. B or Mr. A. So, it is treated as a void one. Next one, not declared to be void. That means the contract not declared to be void. As per Indian Contract Act or Indian law, 5 categories of contract are declared as a void by law. That is, an agreement restraint of trade, an agreement restraint of legal proceedings, an agreement, uncertain agreement, wagering agreement, etc. So, if the parties are entering for these types of contract, they are treated as a void one. The last one, intention to create a legal relationship. When one party make a contract with another one, their intention must be to create a legal relationship between the parties. Otherwise, it is treated as a void. For example, one of our friend invite them to his home to dinner. It is not treated as a valid one, because there is no intention to create a legal relationship in this contract. So, while making a contract, the parties must have the intention to create a legal relationship between them. These are the 10 essential elements of a valid contract. Let us conclude that we discussed with the contract. Contract is an agreement which is enforceable by law, and two things are there: agreement plus enforceable by law. Then 10 essential elements. First one, there must be an agreement between the parties. An agreement involved valid offer by one party and valid acceptance by another party. Second one, identity of mind. Identity of mind means both the parties must understand the subject matter in the same sense or in the same time, in the same meaning. Third one, capacity of parties. Capacity of parties means the parties must have the capacity to enter into a valid contract. That is, he should be a sound mind, major, and not disqualified by any law. Next one, free consent. The consent is said to be free when it is not influenced by coercion, undue influence, mistake, misrepresentation, and fraud. Next one, lawful consideration. The concept of consideration deals that both the parties must be benefited by something. The benefit is known as consideration. Next one, lawful object. While making a contract, the parties are not entered for the object or subject matter is illegal, immoral, or against to public policy. Next one, the terms of agreement must be clearly specified in the agreement itself. Next one, there should be a possibility of performance from the part of a contracting parties, otherwise it is treated as a void. Next, not declared to be void by any law. There are 5 categories of contract. Already we discussed that are treated as a void. Examples, restraint of marriage, restraint of legal proceedings, uncertain agreement, wagering agreement, etc. The last one, the parties must have the intention to create a legal relationship between them. Dear students, hope everything is clear, and I just conclude my topic. If any doubts, you can ask. Okay, thank you.